It's Dina Dahl and Lisa Graves, and we are breaking down a brand new preliminary injunction stopping Trump's executive order where he tried to end birthright citizenship. Let's get into it. If you haven't hit the free subscribe on Legal AF channel, be sure to do that. There's so many developments in birthright citizenship and many others. So as we know, the Supreme Court said there's no such thing as nationwide injunctions anymore. And so this went back down to the courts. And we had a class action filed in New Hampshire where it was a pregnant woman, some parents and some infant children filed saying that they were representatives of the class, that this executive order is affecting them and it needs to be blocked because it's unconstitutional. The judge certified the class action and granted the preliminary injunction. They basically certified the class for the children, not for the parents, but the children who are the ones affected because they're the ones, whether or not they're going to become citizens or not. So let's talk about this, Lisa. Do we think this is as effective as a nationwide injunction? And then we can get into a little bit about the particulars of a class action, because as we know, we're going to be talking much more about class actions over these next few years with Trump, because that's going to be the new mechanism for how to stop Trump's lawful actions.
Yes, that's right. And, this case, it was, I think, a really important breakthrough, a real vindication for our Constitution, for our basic rights here in the United States, as articulated in the 14th Amendment, for this judge to certify this class action. Last week, after the Roberts Court, this right-wing faction that dominates the Supreme Court, issued this, again, another unprecedented ruling from the Roberts Court, asserting that there should not be any nationwide class actions nationwide injunctions, that was suddenly not permissible after it had honored numerous nationwide class actions and numerous pieces of litigation that have come to the court, including not, attacking nationwide class actions when they were issued by Matthew Kacsmaryk in Texas to try to stop mifepristone from being available as medication abortion. So suddenly now, when Trump is the defendant, in essence, suddenly this majority Republican appointed court decided last week that nationwide injunctions could not be issued. And they claimed that, in essence, the individuals would have to sue. Individuals could, make their case. And so what that meant to us when we looked at it over in my neck of the woods was the Supreme Court was saying, babies get a lawyer, basically. Mm-hmm. You're going to have to get a lawyer to defend your rights. But the litigators who were involved in that case basically said that they were going to immediately file for class action relief. And class action relief is a really important and also longstanding process in American law. And so I was really glad to see this decision. I was glad the judge acted so promptly, because this administration, as Michael Popak has been covering this past week, refused to commit to procedures basically to protect the rights of Americans born in the United States, and seemed to indicate that they were going to be moving forward very quickly in response to the Roberts Court saying that there could not be a nationwide injunction. So what do you think, Dina?
Mm-hmm. I mean, I think that this obviously is he worked so quickly, which is great, because a lot of times we see these judges acting as if time, that we have all the time in the world. And this is clearly not the case. The class action was filed pretty much right after the Supreme Court did their ruling. And then there has not been that long. In order for there to be in order to certify a class action, you have to prove three things. You have to prove numerosity, which is that there are just too many people covered by whatever the issue is that you're suing, that having 1,000 cases, 100 cases, 1,000,000 cases is so inefficient for our court system that we need to group them all together into a class. So that's one of them, is numerosity. The second one is how typical the issue is. Is it something that is is the issue going to apply in a way that, it's not as if I'm harmed differently than this other person, because then you can't address the harm, right? It would be, then you can't really group somebody together. But in this kind of situation, you take away somebody's citizenship, we're all going to be treated the same. So that's it. And then the third criteria, there is commonality. and whether or not they have the same questions of law. And clearly that is the case when you're dealing with, is this executive order unconstitutional or not? So very clearly, at least in this particular situation, class action, I'm not surprised it was certified and certified so quickly. We may not always have a situation where when we want a nationwide injunction, a class action can be certified, right? I mean, there
Yep.
may be more
Yep.
differences where harms are different, come a little bit different laws and facts, but not in this case. This case, it was pretty clearly could be certified. So that is helpful in that situation because, you know, you had after that Supreme Court, the reality was you had a lot of people who were in fear that their children weren't going to be
Yep.
citizens, and so now now we can get to the substantive issue.
Yep. Yep.
Of whether or not this law is legal or not, because of course the Supreme Court was never looking at that. They were looking at the mechanism, and of course, ironically, and Elisa maybe can speak to this a little bit, was when Trump, he lost right at the lower court. They could have asked the Supreme Court to look at the denial of, the lower court essentially thought that and said that the executive order was unlawful. Trump didn't ask the Supreme Court to look at that. He instead asked them to look at nationwide injunction because they knew they were going to lose at that issue. So now we're finally going to get to the substantive issue of this.
Well, I really appreciate your explanation of class actions because I think a lot of people hear about them in the news, or maybe they've seen a movie or a movie even called Class Action, but they don't really know what those legal thresholds are. And in this case, in terms of the citizenship of people born in the United States, to me, it's a clear-cut case where certainly a class action could be certified because of the factors you mentioned. The people who are affected by this order, this incredible, outrageous, in my view, anti-constitutional edict by Trump right away after he was sworn in as president, they're basically trying to say that any child born in the United States after late February to the present and going on into the sort of indefinite future is not a citizen, even if they're born here, if their parents aren't citizens, both parents, that they don't have a parent who's a citizen. And if their parents are here, on a student visa or an H-1B visa or, some other visa, that they're not actually American citizens. That's crazy. It's also sort of crazy from, a president who married an immigrant and has a child. Not that this would affect them because of his citizenship, but you could see how this would be, if it were applied retroactively, it could be used by this administration to target Kamala Harris because her parents were students when she was born in the United States. There's so much mischief that this administration could do if they prevail on the underlying substantive issue. But as you point out, in this case, this is such a in my view, clear-cut case of why a class action is warranted. And like you point out, now we're going to get to the heart of the substantive matter. And Judge Kuhnauer on the West Coast up in Washington was one of the first judges to get one of the initial cases. He was a Reagan appointee. This is no liberal. This is someone who's been on the court for a long time, has a reputation for his conservatism. And he when he got this case, a similar case, he said this was blatantly unconstitutional because it is. This effort by the Trump administration goes against over a century of law, including a Supreme Court ruling more than 130 years ago that dismissed the claim that someone born to immigrants here was not a citizen, because the United States in that 14th Amendment clearly made it so that if you're born in the United States, you are a citizen. And so, I am looking forward to the substantive rulings in this case. But as you point out, I'll just flag one other thing. It is this class action option is not an option for all of the challenges we're facing with this administration, because I could see this administration arguing for people who are facing deportation, maybe for a criminal act or a conviction, or where they may have made a mistake on a form, that those circumstances may be different and may be difficult for a judge to issue a class action, to certify a class action, because some of those underlying factors may be different. But here, it's a very clear class of people, babies who've been born in the United States in the last 4 months, babies who will be born this summer and fall and going forward, who are being denied their basic right to citizenship by this administration based on these few very specific categories that would exclude potentially, certainly hundreds of thousands of people born in the United States from their rightful citizenship. So I think for me, I applaud this decision by the judge in New Hampshire.
I mean, the irony is not only is this case such a good class action, but it actually was also the worst case to say nationwide injunctions were bad, I think, because it wasn't just the one judge. That's the irony. Trump is like, oh, the one judge is holding it up. There was 3 judges and they all agreed with it. So the irony was this wasn't even what you would say an abusive nationwide injunction like the Kaczmarek judge in Texas, the one sole person. You actually had multiple judges in multiple states all come to the same agreement. So the irony of this case is it was a bad use of the Supreme Court to overrule nationwide injunctions, but also a very good class action. One thing, once we go to the substantive, and then we can wrap up, is Claire, the one thing that made me feel good is that Justice Clarence Thomas did not, in his concurrence, point out anything bad about birthright citizenship, because we know he does that, right? Like when he pointed out in the Trump decision about Jack Smith and the independent counsel, even though he didn't have to. And I was a little bit worried that he was going to say something about, alluding to his support for repealing birthright citizenship, but none of them did. I think that's a good sign that they are not where Trump is in this. And but be sure, fingers crossed, you never know with this Supreme Court. They may have been hiding their cards, but he could have signaled a little bit, as he did with the Jack Smith. Hey, district court judge, this is how I want you to look at it. Yep. And he could have had somebody, a pro-Trump person, kind of take that mantle up, and he chose to not to. But be sure to free subscribe, because if there's more updates on this, Lisa and I will try to cover it, or Lisa and I will do it separately. But we're always here on Legal AF trying to get the information out as accurately and as quickly as possible.
Thank you, Dina. Thank you, everyone.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.